This week's legal update is about what employers ought to do in dismissing the employees on account of poor performance. We give this update because over the last few years, there have been numerous cases in the Employment and Labor Relations Court where employees have accused their former employers of dismissing them on account of poor performance without following the due process of law. So today's paper will highlight on what employers ought to do and the process and all the procedures that employers ought to follow before dismissing an employee on account of poor performance. The courts have now come to give guidelines on what employers ought to do before dismissing an employee on account of poor performance. The reason behind this is that when you recruit an employee, you've recruited based on a competitive process, and you have to interrogate if that employee is not performing well, the reason behind his performance. You have, first of all, to give to the employers to go through the performance improvement plan, the PIP, and then after you found out that they said the employee has not met the targets, is now when you form a disciplinary committee to look into the same. So the key consideration in dismissing an employee on account of poor performance would be that the employee should have failed to meet the agreed standards or what you've already set out to the employee and he has not met. Now, poor performance can also be seen as unsatisfactory job performance and the employee's actual performance, and therefore there is a gap that ought to be addressed. And therefore, when the key aspects of undertaking an evaluation is one, you are supposed to involve the employer has to plan, has to have a plan on the same. You are supposed to give the employee the set targets, because you can only rate poor performance based on the rate target, the targets that have been set. And then you're supposed to continue monitor those particular performance. You are also supposed, the employers are supposed to give the kind of support to the employee. If, for example, the employee has not been performing because he does not have specific required technical know-how, it is now incumbent on the employer to improve those the technical aspects of the employee. Now, once now the standards have been set, you are supposed to go under what is called the performance appraisal system and the performance improvement plan. Now, what do I mean by the performance appraisal system? Now, an appraisal is the formal assessment that of an employee, and I believe before an employer, it's good practice for every employer to have an assessment, to appraisal of the said employee. Now, during the performance appraisal system, those standards are supposed to be met. However, the courts have said that you should, when you are giving those standards are supposed to be reasonable, understandable, verifiable, measurable, and equitable. And after the appraisal, if there is some aspect that the employer has indicated that he needs some assistance, those assistance should also be given by the employer. And if, for example, there is a disagreement, maybe on an issue between the supervisor representing the employer and the employee, either on the conduct of the outcome of the appraisal, an appraisal grievance presents itself and the employer must provide an objective forum towards resolution. For example, if there is a point of divergence between the employer and the employee as regards a specific aspect, there has to be a meeting between the two try and solve. So poor performance ideally puts more spotlight on the employee, that really you should not dismiss an employee, because the basis is that the moment you recruited this employee, he was meeting those particular targets, and therefore he cannot just come one day and he fails and then you go ahead and proceed to terminate his service. Now, that aspect is what is called the performance improvement plan. Now, this is a tool of progressive and consistent monitoring of an employer's performance once found to be below expectation, with the aim of addressing his unsatisfactory performance issue. And therefore, it provides an avenue through which struggling employees can clearly can closely engage with the management, developing strategies aimed at improving performance. Now, during the performance appraisal, you may find that the employee has not met specific targets, and therefore that employee is now put in what is called PIP, that's the performance improvement plan. Now, the essence of a PIP is now a way now to address the specific aspect that was noted during the performance of an employee not meeting his expectation. And therefore, as we noted earlier on, the employee, the spotlight is now put on the employee if he is now going to meet those particular targets. And the objective of performance improvement plan should be, one, you are supposed to explain the deficient performance and why it needs to be corrected. Now, during the performance appraisal, there is a gap that was identified. Now, when you are putting now the employee under PIP, you are supposed to specifically address those particular concerns with the employee. Number two, the employee is supposed to provide the specific expectation and describe the desired performance in either qualitative or quantitative terms. The keyword that is used, as I noted earlier, the standard should be SMART. SMART meaning S for specific, measurable, attainable, relevant, and timely. Now, you are supposed to tell him, yes, you failed in this particular aspect. Now, the SMART principle apply. That you are supposed to meet these aspects within this particular time. Now, the employee is now supposed also to develop an action plan that follows the SMART guidelines. The timeline should be set based on areas of improvement cited. Maybe you can give now an employee the timelines. Is it 30 days you want him to improve on a specific aspect? 30, 90, or 120, depending on the case. The fourth aspect is that the employer has to allow all reasonable time to resolve the deficient performance and establish periodic review. Now, there should be a periodic review. If it is within 1 month, a review 30 days. The employer is supposed to have a continuous review within those particular timeline. And then number five, the employer has also to describe the resources available to assist the employee, including coaching, training where necessary to meet the objective. We indicated that the employer has also now to put in resources. If you have identified a gap, does it mean coaching? Does it mean training to address that particular unmet expectation? And then next, the employer has also to allow for objective periodic performance review or performance and inform the employee how his performance will be monitored and reviewed. And lastly, you should notify the staff of the consequences of continued deficient. Yes, it should be very clear that any deficient in failing to perform or to meet the set targets will lead to termination of employment. And therefore, if after the PIP, the employee has not met his target, the next course of action is now to go under the provision of Section 45 of the Employment Act. If he has gone through the PIP and has not met target, the first aspect for the employer is to issue a show cause letter. Now, the show cause letter will detail the grounds onto which you want to dismiss the employee on account of poor performance. Then a disciplinary committee will be formed based on the company's human resource manual. After the disciplinary committee has been constituted, is now when you will terminate the employee on account of poor performance. Now, as I've explained, therefore, poor performance is a two-staged process. It's not like the other cases of terminating, for instance, summary dismissal, whereby in summary dismissal, where an actionable or a cause of action has arisen as regards an employee, the show cause letter is issued. Therefore, after a show cause letter has been issued, a disciplinary committee is constituted, and thereafter a termination of the employee is given. Therefore, in conclusion, therefore, poor performance is subjective, and the employer must demonstrate the basis of such finding. And before an employee can dismiss an employee for poor performance, the employer has to show the resources that he provided to help this particular employee meet a target. And we are happy to inform you that one of the cases that guides this particular process is the case that we litigated. This is the case of Christopher Onyango and 24 others versus the Heritage Insurance Company, whereby the court indicated as follows. Just read the excerpt. The court said that the subject of poor performance of an employee is a serious matter. Such requires thorough investigation before an employer can use such as a reason as the basis for termination. That the rationale is that the employee is hired for being competent for the job, and upon confirmation such an employer has been put to the test and passed. Where an employee works for a long period and suddenly decline their performance, the root cause must be established. A credible performance appraisal process must be participatory, with parties sharing comments, and where the employee is left out, such cannot pass. And therefore, it is not sufficient for an employer, as indicated earlier, to cite poor performance as a reason for termination. The employer must demonstrate what measures he has put in place to support the declining performance by the employee. And that despite the support, the poor performance, employee has not made effort to improve, and hence the reason for termination. Now, where the performance development plans, performance improvement plan, or capable hearing is used as a tool to address poor performance, the reason must go into its implementation, and that the employee must know from the onset that such a tool is not only meant to assess their level of productivity, but also as a tool to address their work performance. And in event there is the below required performance, then the motion for Section 41 of the Employment Act shall fall in place. Therefore, to conclude, performance is a very critical aspect, and the employers are advised to follow the strict processes that have been set by the courts, lest if they dismiss the employees on account of poor performance, such termination will be rendered, will be set aside, and the courts will give a verdict that the said employee was terminated unfairly and unjustly. I want to thank you for hearing this week's legal update. This legal update, the comprehensive paper, has been published on our website. You can check our website for the same. This paper was jointly written by Maureen Sumba and myself, and we want to thank you for your continued support.